You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hello and welcome to the LemonAid Podcast with experienced attorney Shalev Amar. I am your host, Kevin Rosenquist, and on this podcast, we discuss lemon laws. Shalev, thanks so much for being here.
Thanks for having me.
All right, so today we're going to go over lemon law versus consumer fraud, and there is a difference. So start out by telling us how lemon laws differ from general consumer fraud laws.
Well, what lemon laws are warranty enforcement statutes. So if a vehicle is in a repair shop too many times for the same substantial issue or for too long for warranty repairs, the lemon law steps in, says enough is enough, enables you to recover typically attorney's fees along with either a vehicle repurchase or replacement. And a compromise is also generally possible when you bring that type of claim of cash compensation with keeping the vehicle, also including attorney's fees. Also, if a vehicle is not repaired when it should be under warranty, that would also provide the basis for a lemon law claim. Now, consumer fraud claims, those are typically in a motor vehicle context related to non-disclosure or concealment. So let's say a dealership sells a vehicle that's been in a major car wreck and doesn't disclose that to you, that would be consumer fraud. Let's say there is a substantial recall where the vehicle is catching on fire and that's not disclosed to you prior to sale, that could also be potentially a fraud claim. And there's a variety of scenarios that could fall under fraud. But the main thing is that typically a seller is selling you a product and not disclosing a material fact about that product to you. And by material, it means it's information that would have affected your decision, basically your buying decision, whether you would buy the product or not. So if it's material, it should be disclosed. And if it's not disclosed, if something, there could be outright lies. You say, no, the vehicle's great. Never been in an accident, perfect condition. The vehicle's been in 3 wrecks. That's a blatant lie. Or on the concealment side of things, it'd be like they're well aware that the vehicle has some kind of substantial issue. Like I said, the most common is accident damage. It could also be flood damage or vandalism, and the dealer's fully aware of it, and that's not disclosed to you. So all those things could fall under a fraud claim.
Are there any situations that could fall under both lemon law and consumer fraud statutes?
There's actually one very specific scenario that falls under both, and that is what is called lemon laundering.
Lemon what?
Lemon laundering.
Laundering.
It's
all
basically
right.
laundering of a lemon vehicle. So that can be done several ways. Typically, when a vehicle is bought back under a state lemon law, it's then reconditioned and sold at auction to various dealerships. And what can sometimes happen is the dealership will then resell the lemon brand vehicle without disclosing that fact. And under state lemon laws, there's typically notification provisions that require lemon law buyback notification affixed to a vehicle, and also typically a form that should be provided to consumer disclosing the vehicle's lemon history and requesting signature. Now, look, a lemon vehicle can be purchased. It's just about disclosure, because the issue is that what oftentimes happens with lemon laundering is the dealer will remove the notification that the vehicle is a lemon from the vehicle. They'll remove the sticker, and then they'll just shred the form that comes with the vehicle disclosing its history. And then they'll sell the vehicle as if it's a normal vehicle with a clean title, clean brand, no adverse history. And oftentimes what happens is the consumer will not discover that until several years later when they go to sell or trade out of the vehicle. And then the dealer is saying, well, I'm only going to give you half of the normal Blue Book value because this is a lemon brand vehicle. And then for the first time, the consumer realizes that they were defrauded and that the lemon law was violated. So that's a situation where it's both a lemon law violation because the notification must be provided to a consumer under the state lemon law. But it's also consumer fraud because, like what we were talking about earlier, is if it's something material about the product that you're selling, and the fact that it has a lemon brand and a lemon history that was bought back under the lemon law is definitely material, definitely substantial information that any consumer would want to know, that's fraud if the disclosure isn't made.
Have you seen that a lot? Like, is that frequent?
Well, it depends on frequent. It does happen.
Yeah.
Several years ago, a predecessor firm that I worked at, we actually do not handle fraud claims, but at my old firm, we did. And yeah, there was a dealer that was engaged in lemon laundering on a mass scale. And what this dealer was doing was actually forging people's signatures on the lemon notification forms because that particular manufacturer, and I can't get into details for confidentiality reasons. I mean, the cases were eventually settled. But that particular manufacturer, in order to transfer title, because the manufacturer doesn't want to get sued for non-disclosure, they required that they get signed disclosure forms back from the dealership that were supposed to be signed by the consumers before they would hand over the title. And so this dealership, they were forging people's signatures.
You can't do that.
Oh yeah,
you can't do that.
Yeah, that's not just fraud, it's a crime.
It's a crime, yeah.
We put a stop to it. They don't do it anymore, I'll put it that way.
Good. Could you explain how a fraudulent misrepresentation of a vehicle's condition can intersect with lemon law protections?
It's basically the way that I was explaining to you. If, say, a salesman is telling you, oh, this vehicle is great, it's like new, no accidents, I would sell this to my mom. A funny story, one of the other dealers I sold to that I went after for fraud, this was years ago. The owner of the dealer, it's a weird story. The ex-wife,
I like weird stories,
because like we got a default judgment against this guy because he disappeared, and she randomly came into my office and was like, I'm his ex-wife. I can help you find him as long as you give me whatever crazy percentage of the money you recover from him. He used to say I didn't agree, but she told me this story about him where he sold his own stepdaughter a wrecked vehicle. So maybe they aren't telling the truth when they say they would sell even to a family member.
Oh, jeez.
In any event, yeah, that's the main way that there's an intersection because, again, you're allowed to sell a lemon law buyback vehicle. In fact, my own wife purchased a lemon law buyback vehicle, but it had very low miles and it was a minor issue and it was disclosed to her. So she did get a discounted price. In her mind, because it was a minor issue, she will keep a car for 10, 15 years. That's just what she does. She didn't really care because she was able to buy the car for a cheaper price. And again, that's fine. You can sell a lemon vehicle. You just have to make proper disclosure. And if you don't make that disclosure, and you're saying the vehicle's fine, that's obviously a misrepresentation. So again, it's violation both of the notification provisions of state lemon laws, and it's also a violation of consumer fraud law.
Well, your wife probably felt comfortable with that because, well, she was married to you. So if anybody's okay to buy a former lemon, I think it would probably be someone who's married to someone like you.
Yeah. Well, again, it was a minor issue.
Yeah. Can you file both lemon law and a consumer fraud law, or do you have to choose one or the other?
No, you can file both. When you're filing a complaint, there needs to be what's called the same nucleus of operative facts. So to put that into English, it just basically means that it can't be completely unrelated. But if there is some relation, either in time or in facts or in situations, you can typically bring both claims. So what's a case where that could happen? Let's say somebody buys a vehicle that was in a minor accident. It was cosmetic damage. It wasn't to the frame or to engine components. Let's say it's the rear bumper had to be replaced. But, it wasn't just that. It was also quarter panels, and it was a several $1,000s repair. Let's say that's not disclosed. And at the same time, and I've seen this happen, because the vehicle was being test driven before it was sold and somebody damaged it, either a worker at the dealership or a potential buyer who is test driving the vehicle. And the dealership repairs.
That'd be embarrassing if you're on a test drive and you've wrecked a vehicle.
Yeah, it can happen anytime.
That's a bad day.
Yeah, definitely. So let's say that happens, the dealer repairs the vehicle, then sells it to you as new, does not disclose the accident damage. So you're unaware that the vehicle has had accident damage. Now, after that, you start having transmission problems, and you're in the repair shop 5 different times in the first 10,000 miles for transmission repairs because the vehicle's, kind of hesitating and shaking on you, and it's all transmission related. Well, at that point, because these are warranty repairs, you have a valid lemon law case. And the transmission is definitely something that's substantial. And so that's a situation where, let's say the consumer gets rear-ended. They go to get accident repairs, and when the vehicle is inspected, their insurance company tells them, hey, this vehicle doesn't have the same original manufactured parts. These are replacement parts. So that indicates this vehicle has been in a prior accident. Are you aware of that? Oh, no, I wasn't. They never told me. So that's a case where you would have both a lemon law claim against the manufacturer and a fraud claim against the selling dealership for non-disclosure.
So it's pretty specific if you to do both. It's a pretty specific situation.
Yes, it is. It has to be a situation where there has been both either misrepresentation and concealment by the seller, but also too many defect repairs, which would be the manufacturer's responsibility.
This might be a loaded question, but what steps should consumers take to protect themselves from falling victim to fraud when purchasing a vehicle? I'm sure there's lots of steps, but what are the ones that you feel like people really need to know?
Well, always run a Carfax history report on a vehicle. That's just a no-brainer. You should always, I wouldn't just ask to see the Carfax report. I would run it yourself. I don't think it costs that much money to run a single report. It might be, if my memory is correct, it might be $25 or so. It's well worth it before you invest thousands of dollars into a vehicle and make that kind of massive financial commitment.
Just out of curiosity, are you saying to do it yourself just to ensure that it's accurate?
Yes, because sometimes dealers will give you an incomplete Carfax.
Okay.
So I would recommend doing it yourself. I would also say that, especially if you're purchasing a used vehicle, you need to take it to a mechanic and get it inspected. Just have them put it up on a lift and just make sure there's no accident damage. Because sometimes there could be an accident that's never reported in Carfax, like the scenario I told you about where the dealer did an internal repair and no insurance company was involved. That might not show up on Carfax. Or sometimes, even if it is a regular repair issue, the repairing dealer just might not report it to Carfax. So Carfax is not 100%. I mean, it's helpful, but I recommend to people, especially if you're buying a used vehicle, to get the vehicle inspected. Again, it'll cost you some money, but an ounce of prevention is worth a pound of cure, as the saying goes. It's much better to avoid this type of situation than to get stuck with a previously wrecked vehicle or previously lemon branded vehicle.
So if I'm at a dealership and I really like this used car and I think I want to grab it, should I grab my phone and do the Carfax right then and there? Or do you think it's worth going home and researching a little bit and then coming back and purchasing the car?
I mean, with technology, with smartphones, you can do it right then and there.
Just do it right then and there. Yeah.
But I would also, again, I would definitely recommend, if it's a used vehicle, to get it inspected. And if the dealer doesn't cooperate with that, no deal. Go somewhere else. That in itself is a huge red flag.
Yeah, if they're not willing to do that. Yeah, that's a good point.
They're not willing to let you do that. And then obviously don't get it inspected at that dealer, get it inspected.
Yeah. Okay, yeah, we'll inspect it. Steve over here will do it for you. He's my buddy. Yeah. What are the penalties or consequences for manufacturers or dealerships that are found liable for consumer fraud on top of lemon law violations? It's
very case by case. I would say it's kind of like, the punishment typically will fit the crime. That also applies in a civil law context. So I would say the more major the issue, the higher the potential liability. And also what could come into play is something called pattern and practice. So under the law, there's a big difference between something happening one time versus a pattern and practice of defrauding many people. So let's talk specifics. Let's go back to the lemon laundering situation. If it's just one vehicle and it hasn't happened with any other vehicles, punitive damages are available for a fraud claim like that. And punitive damages are damages meant to punish a wrongdoer and to deter them from doing that thing again. And so it's not based on your damages, it's just based on punishing the offending party. And so if a dealer just does it one time, the punishment will probably be less severe when it comes to punitive damages.
Sure.
Now, let's say it's a dealer that's done it to 150 people over a 3-year time period. Well, if a jury hears that, you could have pretty substantial punitive damages. And the standard that the Supreme Court has set is that punitive damages can be up to 10 times the amount of your actual damages. So if it's a $50,000 vehicle and there's a pattern and practice of fraud, you're looking at $500,000 in punitive damages potentially on the high end. And when it comes to lemon law, I would say the damages there are not as substantial because the main lemon law remedies are a vehicle repurchase or replacement. Some states do have what's called a civil penalty, where you can get up to 2 or 3 times the cost of the vehicle, but it's obviously not the 10x like punitive damages. So let's say you have a manufacturer that has a pattern of laundering lemon vehicles. They're just reselling them at auction and not putting the notification stickers on the vehicle and the notification form for consumers. If a manufacturer is caught doing that, then they could be liable for the civil penalty under the state law if it has one, but also for punitive damages under a consumer fraud law.
Okay. Gotcha. All right. Well, thanks for tuning in to the LemonAid podcast with experienced attorney Shalev Amar. Shalev, what's the best way for people to get in touch with you if they have questions or think they might have a claim?
Well, we operate mainly in the Southwest with one outlier state being Nebraska. And so the best place to find out more about your rights, about how the law may or may not apply to your vehicle, is to just visit our websites, depending on the state that you're in. If you're in Arizona, it's ArizonaLemonLawAdvocates.com. If you're in California, it's CaliforniaLemonLawAdvocate, no S.com. If it's Washington, it's WashingtonLemonLawAdvocates.com. If it's Oregon, it's OregonLemonLawAdvocates.com. Utah is UtahLemonLawAdvocates.com. Colorado, it's ColoradoLemonLawAdvocates.com. Nevada is a little bit different for us. It's NevadaLemonLaw.info. And Nebraska is NebraskaLemonLawAdvocates.com. Also, you can feel free to call our team toll free in any state that you're in. And that number is 1-866-904-2627.
Awesome. Well, thanks so much, Shalev. Really appreciate that. Everyone, thanks for being here. Be sure to hit that like and subscribe button and leave us a review in the comments. Shalev, great to see you as always. Looking forward to it again.
Thanks for having me as always. Appreciate you.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.